Welcome back to Public Affairs on Peach. I'm Gurveer Dinza. We're discussing sexual harassment this week, and now we're going to focus on the LGBT community. And joining us this morning is Greg Nevins, attorney for Lambda Legal. Thanks for being here.
It's great to be here.
So, do you get a lot of sexual harassment complaints with your organization?
We have a help desk, and people call us for a lot for employment discrimination, but not so much sexual harassment. And I think it mainly it's because we specialize in areas of the law that aren't as well established, and they could talk to some of the other lawyers that you've had on this program,
right,
to handle their sexual harassment claims, because basically, sometimes if a woman is sexually harassed at work, it could be because she's working late. It could be because she's a redhead and that's what the harasser likes, or maybe because she's a lesbian, or maybe because she's not a lesbian. But
right.
But none of those matter in the sexual harassment context. It's the fact that she's a woman, and it is what matters, and it wouldn't be happening to her if she weren't a woman. So that's actually very well established in Title VII laws. So they wouldn't as much need to call us. But people who experience just basic discrimination for being LGBT,
right,
they call us because a lot of lawyers aren't as familiar with the arguments for why it's covered under Title VII. So they come to us so that we can, because that's what we do.
At the end of the day, sexual harassment, whether you're a man, a woman, whatever, whether it's man on man, woman, it doesn't matter. At the end of the day, the basic, the common thread is sexual harassment.
Yeah, absolutely. And what's interesting about that is that you pointed out that it wasn't, the EEOC didn't rule it was illegal until 1980, and then it wasn't until 1998 that male-on-male sexual harassment was declared by the Supreme Court to be a violation of Title VII. And everybody was going like, really? That's not why they passed this law in 1964 to prevent
right,
male-on-male sexual harassment. But the court said it doesn't matter why they passed the law. What matters is the words of the statute that they passed. And what they said is you can't treat similarly situated people differently because of their sex.
Right.
So
right. Exactly.
Yeah. So if it wouldn't happen to you if you weren't a man, that harassment wouldn't happen, or if your discrimination wouldn't happen. If you weren't a man, then you have a claim under Title VII.
You've got a really interesting case you're working on in Savannah, right? I mean, it's not specifically a sexual harassment case,
right,
but discrimination for sure.
Yes, Jamaica Evans is a lesbian who is working for Georgia Regional Hospital in Savannah, and she actually she experienced terrible discrimination and harassment, and actually pursued the case herself. I mean, she hadn't heard of us at the time, and she went to the EEOC herself. She went to the Southern District of Georgia, and her case was thrown out, and then we stepped in in the latter stages of that to try to help stop that, but it didn't work. And then we took her appeal up to the 11th Circuit, and that's the federal appellate court here. And we were hoping that they would, recognize that how strong the arguments are for that Title VII should cover this, as other courts around the country have. But they actually decided not to rehear the case in bank. That would allow them to actually overrule old precedent.
Right.
That's what happened. The federal appellate court in Chicago did that, and the federal appellate court in New York. They haven't ruled yet, but they actually reheard it, and they're now re-examining their precedent. So, but the court here in Atlanta did not want to do that. So that's why we took Jamaica's case to the Supreme Court. That's why
as I watch all these sexual harassment cases unfold in front of us with the Bill O'Reillys and the Weinsteins and all the others, Kevin Spacey, another one, and Kevin Spacey, after that sexual harassment claim came out, said, "Oh, I'm gay." So I wonder sometimes if people are hesitant to speak up in a workplace environment because they may not have come out yet. Maybe they are not ready to admit that they are, in fact, gay or lesbian.
Oh, no, I mean, that's a significant problem. As a matter of fact, what's interesting in our in support of our request for the Supreme Court to hear the case, over 75 businesses filed a brief, and they said, you should hear this case and you should rule that Title VII covers this kind of discrimination. And their approach was that we believe that our employees are at their best when they can bring their full selves to work, when they don't have to worry about being outed, when they don't have to worry about the discrimination. So so you're absolutely right, and businesses recognize that.
Thank you very much. We appreciate your time today, Kevin. That is some information that we need. Stay with us. We'll take a look at what Metro school districts are doing to stop harassing behavior, beginning with the youngest students, when we return here on Peach.